Enoye Extreme Media UJ. Subscribe for all updates.
State prosecutor twagala ebibuuzo ebyo babimulize mu kamera eri nga bannamawulire tebaliwo nga ne public teriwo, tugende mu chambers tukwate n'enzigi tuziggalewo bateekeko ne kufulu esibireeyo tumubuulize eyo mu nzikiza ebiba eyo public ereme bimanya. Ekyo kitwewuunyisizza nnyo ne twebuuza kiki kye bakweka bw'abanga ddala ayogera mazima nga byayagala bya bujulizi ddala obugamba nti bwaleeta mu kooti, lwaki ayagala tugende twekweke? Tuwakanya okusaba kwabwe, ensonga zaffe tuziwadde nga tugamba ffe twagala ayimirire mu kageri wano witness stand annyonnyole obuuza akana n'akataano, naye ate era muwulidde state yo ng'egamba nti nedda bo baagala bagende mu kamera. So kivuddemu omulamuzi nakkiriziganya ne state n'akola lulingi naga nti okusinziira investigations zikyali ku stage esooka, waliwo ndowooza ebintu bye baagala okukola nga byankiso babikolereeyo mu chambers. Ffe kituwakanyiza tugaa nti bw'obanga osazeewo eno kooti wali ate kooti ezisingako tetwagala kweyongerayo mu kooti, kino kituwakanye mu nkola gye bayita eya revision. Kooti eyawagula kooti erina obuyinza obwetegereza mu biragiro byonna kooti eno eya wansi byewa nebaako bwebisalawo oba ebikyusaamu oba ebimenyawo oba ebikiriza. Kati ekyo ffe kitusabye naye state era nekiwakanya. Lwero tuli basanyufu final omulamuzi akkiriziganyiza naffe naga nti ayimirize ebyokugenda maaso ne cross examination oba okubuuza mukulu Benedict Odiek mu kamera oba mu chambers okutuusa nga tumaliriza okugenda okujulira kwaffe mu high court. Era omusango ne gwongezebwayo ennaku za mwezi asatu mwezi ogwokuna okujja mu mention okulaba nga wetutuuse. So kati ffe tugenda maaso n'okukola enteekateeka yaffe okuva olwaleero okulaba nga tuteekayo okujulira kwaffe. Kankuyite okujulira ne mu mateeka tekuba apiiri, naye mu Luganda okujulira tuteekayo okujulira kwaffe kusalawo okugamba nti Odiek Benedict bagenda tulina mu cross examiningira mu kamera oba mu nkukutu tugenda tekikkiriza era ekyo tukiwakanya ne sekuwakanya. Twagala kiragiro kya kooti eya kooti egambe nti tumuteeke mu lujjudde wano mu kooti amawulire weegali ng'abantu bonna we bali ebibuuzo bibuuzibwawo, kubanga state ye yatandika dde ebintu bino era neegenda ng'egira ebintu byejoteka ku Dr. Besigye. Kubaka twebuuza yo lwaki state yennyini eyatandika okufulumya ebintu ebitalina mutwe n'amagulu nefulumya bu audio negamba muwulirize, simanya Besigye wuuno alamuze emmundu, simanya Besigye wuuno agenzaako okunoonya esente Sweden Greece ziwuno simanya luddawa. Ne batandika okuteekayo obuloboozi obwo bagezeeko okuprejudicinga case. Kakati babuteekayo era mwalaba n'ennaku ezo nga boogera n'ebigambo bingi, abasajja nga bamwenda nga boogera ebigambo bingi. Oyo Besigye yali agala kutta Museveni, oyo Besigye ayina kino, obujulizi buno, obujulizi tubulina. Ne bademerako bonna bawulira obujulizi Kuleyije bonna bagamba obujulizi tubulina. Kati Mukweeka bwaki muluteeke wano mu lujju, bw'aba Odiek abulina jangu wano yimirire mu kagulu tugende kubuuza kataano ku bibuuzo lwaki otayagala bagende mu lujju. So ekyo tugenda kulemerako era tugenda kooti eyawaggulu.
State eganda nti muzannya bukodyo okutereera justice mwenge nnyini.
Ebyo situjja kubiddamu kubanga ffe twagala obwenkanya. Mumanye ennaku Dr. Besigye n'Obedi Charles bamaze mu kkomera babakwatanga 16 Novemba omwaka oguwedde ne babatwala mu General Court Martial ne tuguba ne tulwana olutalo Sematalo ne tuluwangula ennaku z'omwezi 3 mu January. Ate era ne bajembera ebiragiro bya bungi nga bazannya jangu okwekola ebya Supreme Court ne balwawo okuleeta Dr. Kizza Besigye. Bagambye nti investigations bakazitandika. So babanga wakwata Dr. Besigye ennaku z'omwezi 16 omwezi ogw'Okuna kaka tuli wano mwezi gwa kuna totandikanga ku investigation otandika butandisi ogamba otya nti fail to delays ani yabali
prosecution. I mean the applicant prays to this court to have the application heard in chamber. This will ensure, one, protection of Mr. Odiek Benedict from public attacks. And threats which are imminent. George, to this court witness, you can hear the singing and everything. So therefore, subjecting having this audience before this court will jeopardize his security. As if that's not enough. As if that's not enough, it will jeopardize the investigations. Because he's still one of the investigating officers in a matter whose investigations are still ongoing. Your Worship, under Article 28, Clause 2 of the Constitution of the Republic of Uganda, 1 and 2 actually. Allow me to read them positive. Under Article 28, Clause 1, Your Worship, it is stated that in the termination of civil rights and obligations or any criminal charge, a person shall be entitled to a fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. And 2, that nothing in Clause 1 above of this article shall prevent the court, in this matter, this honorable court, or tribunal, from excluding the press or the public from all or any proceedings before it for reasons of morality, public order, or national security, as may be necessary in a free and democratic society. It is a submission, therefore, that our application passes the test under Article 28, Clause 2, to protect Ms. Odiek and the integrity of the investigation. Given the nature of the offense and the people and the nature of the accused persons or applicants or respondents in this matter. This application is brought in good faith. It is brought in good faith, and in no way shall the rights of the respondents be prejudiced. And Your Worship,
All of us see. Even him, he was seen. Yet I didn't feel threatened when he was sitting next to me. But again, you note that even if he says singing is a threat, perhaps the songs that were sung were at a time when the witness was not known.
So I doubt that the witness is the one who has told you that he was threatened by the voices and song. But Your Worship, the point we also want to make is that the state has got very many police officers. And under the acts which this application is grounded, the Computer Misuse Act, and the Data Protection Act, it refers to any officer. It does not specify that it must be an investigating officer. So the state had the opportunity to invite any of these several officers. But the state chose to bring an investigating officer. It's clearly not the fault of the accused person who is in custody. It is therefore wrong for the state to try to recover where it slipped in this application at this stage. Your Worship, in any event, the identity, because I understand Mr. Billy Bumbuka to say that they want to protect the identity of the witness. But Your Worship, the identity of the witness has already been made public in the application, which is supported by an affidavit that has his warrant card with his photograph and even number. So the information the state wants to keep private, for whatever means, is already public. Moreover, those details about the witness have been repeated by Mr. Billy Bumbuka himself here. He said the witness is a police officer and the IO. He even mentioned that his name is Odiek Benedict. So we don't want him to state his identity, we want him for evidence. So if it is protecting identity, Mr. Billy Bumbuka has already given it away. That he has done so surely means that the identity of the witness was not perhaps important to be kept private. And moreover, Your Worship, even we counsel can record and are not restricted from saying what the witness shall say in the public, because we are not bound in confidence by this proceedings. We can even draw him here and present his picture, the artistic version, to the public. That is a belated attempt to cure Mr. Bill Bumbuka's. And perhaps Your Worship is saying he wants all members of the public out. Your Worship, the first member of the public in the city is the Lord Mayor. So even we lawyers are members of the public. So perhaps by saying he wants all of us out, he wants the benefit of having the accused unrepresented, which is wrong. No. He did not say excluding the lawyers, he said all members of the public. The assumption is that for him, he's not a member of the public. The other point, Your Worship, is that Article 28(1) and 2 was rightly cited by my colleague. The emphasis is in Article 28, sub-article 2. Nothing in clause 1 of this article shall prevent the court or tribunal from excluding the press from all or any proceedings before it for reasons of morality, public order, national security, as may be necessary in a free and democratic society. Your Worship, that sub-article, that article comes after the right, the presumption being that criminal proceedings should be conducted in the public view. And Your Worship, that stems from Article 126 of the Constitution, which says that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people, in conformity with the law, with the values, norms, and aspirations of the people. Your Worship, the aspirations of the people is that their leaders must be tried in an environment where they can see that proceedings are fair. That is one of the ways in which the judiciary accounts to the people in exercising judicial power. That trials are not conducted in camera because anything can happen in camera. So before the nature of the provisions of sub-article 2 require that before the right to be tried in the public view is removed, the state must demonstrate with tangible evidence that having the press and the public around is contrary to morality, public order, and national security. Your Worship, that requires that the state presents tangible evidence in the form of an application supported by an affidavit, in which it is shown that if the